Thomas Vinje. Very well, welcome to Digital Markets Research Hub. It's a great pleasure to see you, and due to the obvious specialism in various aspects of ex-post competition law, but also your contribution to the development of the discussions in the Digital Markets Act, we will build our conversation focusing primarily on the latest development in 102 and also DMA, looking also at some other issues. But I wanted to start this conversation by noting this remarkable feature or your attribute that you've been involved for decades in the most textbook cases in the EU, in the UK, and obviously in some other jurisdictions. We can call IBM, Microsoft, Google, Facebook, Apple. All these cases you've been participating actively, representing one or the other side in the trial. So maybe we can start this conversation with you very briefly, maybe highlighting your background, your legal, non-legal background, how you combine these features, etc.
Okay, as you can see, my hair is turning very white. So I have indeed been at this for quite some time. I'll try to be quick. I'm Norwegian American, and I have practiced on both sides of the Atlantic, in San Francisco in particular, working on the Fujitsu IBM arbitration about interoperability and issues along those lines. Then I moved to Brussels in 1989. And worked mainly on intellectual property issues in the IT sphere for the first years I was in Brussels. And then Brussels being Brussels, I gradually moved towards antitrust. I pretty much immediately became involved in the IBM case because I moved to Brussels because of representation of Fujitsu against IBM. So I was involved in the IBM case from pretty much the moment I landed in Brussels. And then I think probably my big personal break was when I was plucked out of nowhere, basically, to handle the Microsoft case against Microsoft on behalf of the leading intervener in that case. That was a very formative involvement in that case. And I think it was formative for the European Commission as well. You still find some of the leading people in DG competition were formed by their experience in the Microsoft case. So I pay quite a lot of attention to the Microsoft case. You see it repeatedly referred to in other important cases that come along. And it was really where the European Commission got its expertise in tech issues. Obviously, it's moved on and they've gained much greater expertise. And that's something I have great respect for the European Commission, is the level of expertise in the relevant technology and economics of digital markets. And Microsoft is really where it really all got started. Then I have been involved on the complainant side in Google Shopping. I filed the complaint in Google Android, and I've been involved in other Google matters. Recently, something I've spent a fair bit of time on, or since the beginning of the case actually, is the Spotify complaint against Apple regarding Apple's App Store conduct. So that's one of the cases. It's now on appeal, and we've applied to intervene. So assuming the court accepts us, that will be something that will keep me busy for quite some time, probably. So that's sort of a thumbnail sketch of the cases I've been involved in. I've been supported by a phenomenal team. Nobody who achieves anything does it on their own. So I want to emphasize that.
We'll have opportunity to ask about the success, the recipe for success at the later stage. I have a question for this as well. But to begin with, I propose maybe to start with kind of intellectual disclaimer, so to say, to explain how you see the goals of competition, not as of competition law and policy, not of European competition law and policy, not as a kind of lawyer, but more as a policy, stepping in the shoes of policymaker? Is it something stable? Is it something measurable? Or is, on the contrary, it's something instrumental and context dependent, depending who interprets in what context, etc.? What is the strategic objective of this whole exercise?
Well, first of all, I don't think it's measurable. I don't think one can have sort of arithmetic approaches to competition law and that sort of formalistic approach to it. I think that formalism in general, I am not very fond of, and in that regard, I've been happy to see the Commission move towards an effects-based approach to competition law. What effects-based means is, of course, a very, very big question, which is still on the table today. If I stand back from it, I mean, I have to say that people, over the years, I've seen that lawyers and people generally involved in these policy debates come from a very personal perspective. I have a friend in Germany, and he says certain things are Glaubsache, just a matter of, it comes from within. And I will have to admit, I've been on both sides of Article 102 cases and merger cases and all sorts of cases, and I'm perfectly capable of becoming completely convinced of the righteousness of my client's cause, whether it's a defendant in a dominance case or defendant in a merger case. So I'll do my job, and I can become committed to that, because I think there are always valid, maybe not valid, but there are always arguments one can at least make with a straight face on all sides of these cases. But I come at it with my sort of personal perspective that competition policy is very important insofar as competition in markets drives innovation, it drives consumer welfare. It's important not only in an economic context, but in preserving democracy, in ensuring cultural diversity. In many ways, I think competition in the market writ large is very important to society, in keeping things moving the way they should be moving, is a very vague way of putting it. So I come at that with a very pro-competition perspective, and my life as a lawyer reflects that. I'm not sure I've answered your question terribly precisely.
You did. You did. And the next question is based on what you have mentioned earlier. Unlike most of other practicing lawyers, even if they are very experienced, top-tier lawyers, combine two additional very important features: your technical expertise in understanding maybe not all peculiarity of all digital markets, but understanding the technical side of the story from education, not by intuition. And second one, you've been representing many complainants which can be seen as catalysts, as triggers for important paradigmatic cases. And I wanted to ask, how do you obviously are in continuous communication with them, and how does this business perceive the impact which even the successful ex-post competition cases deliver to their business models, and to how does competition law shape the industry, even if it succeeds after 10 years or whatever?
Okay. Well, with respect to the expertise one has, I think it, first of all, is extremely important for any lawyer who wishes to practice in areas involving technology, whether that's digital technology or other types of technology. Digital technology is, of course, where it's really at today, because digital technology, digital markets are so absolutely vital to today's economy. And so I was lucky. Many things in life derive from luck. And as I said, I began working on that case in San Francisco for 5 years. The great dispute between IBM and Fujitsu about interoperability. And I had to spend countless hours in windowless rooms with software engineers and reading textbooks on software law and really getting into the nitty-gritty of of the technology. Now, I am not a software engineer, and I could not produce the things that brilliant software engineers produce, and I'm very I admire hugely what those folks do. I can't do that, but if a lawyer who's not an engineer wishes to practice in this area, I think it's important to do one's best to gain the technical knowledge that one can that's relevant. Now, I was basically lucky, and then I moved to Brussels and I continued doing work for those sorts of companies. And so it was just part of what I had to do. I wouldn't claim any particular brilliance at all. It's just what I had to do. But I would also say that, you know, I have lots of white hair, so I'm not part of the youngest generation. And something I notice, which it puts me in awe sometimes, is, you know, 25-year-old lawyers today, I'm not sure how they get it, but they have a great knowledge of technology. They know a lot of stuff about how digital technology works that I didn't grow up with. It didn't exist when I grew up, and it's somehow just in their bones. So I'm a little bit envious of younger lawyers these days. But, you know, just stuff you learn growing up in life these days is not going to be enough. You need to have some more detailed technical knowledge to really work in these areas. Then the second question. I guess one could boil that question down to how do the companies that have participated in these cases view the results, the effects that they've had in the world. I've had lots of conversations with clients over many years about that. And there are a great variety of opinions and perspectives. There are some clients who shall not be named, but who are, in my view, not really terribly sophisticated, in the sense that they expect rapid and direct results from competition cases. So if there's a company that feels that a larger, supposedly dominant company is acting contrary to, in Europe, Article 102, and that a case should be pursued against them, and they pursue a case, some companies are far too unrealistic about what to expect. And these cases have become more and more difficult as the courts have imposed greater and greater burdens upon the Commission in all sorts of ways you're well aware of, including procedural ways. And so I don't believe it's wise for any client, and this is what I tell clients who come to me and are interested in pursuing a case, is don't expect rapid, full results that will address your issues in a rapid manner and a very comprehensive manner. It happens. Sometimes you can convince the Commission to send a request for information to a particular dominant company that makes it clear that the Commission is focused on some particular conduct and is likely to pursue that. And sometimes that will cause that company just to back off and change its conduct. So sometimes things like that work. But when it comes to pursuing big, full-blown cases, one needs to be realistic. It's going to take a lot of time. And the remedies are often, unfortunately, not very effective. Microsoft Media Player is the prime example. The Commission does not like to hear about Microsoft Media Player because it was a complete, utter joke. So I'm going on too long about this, but there are some companies out there who expect more than they're very often going to get. But there are others who I regard as more realistic, who will go into it with the perspective of, and thinking dominance cases now. There's the big gorilla, and they are engaging in a bunch of anti-competitive conduct. And there are many things they might come up with in the future that are also anti-competitive. And it can be very useful, even if, for example, the media player remedy was useless. A great spotlight was put on Microsoft conduct. And they ultimately, finally, and I think it was mainly because of the reputational issues that they began to face, because there really was a great concern about how Microsoft was conducting itself, and that was causing it problems in the market because its reputation was being harmed. So Microsoft had had a coming to Jesus moment. They changed, their culture changed. They finally realized they needed to take a different path. And so it had an overall disciplinary effect, even though the changes they made didn't result from any specific remedies that the commission imposed in any case. So this, of course, requires a lot of resources to pursue cases, dominance cases as a complainant. But I think a more realistic perspective is shine a light on this conduct, and you can cause longer term benefits in that regard. I don't know if that is clear enough or makes sense, but
yeah. Well, yes, absolutely. And I even have a follow-up question, if I may, in this regard, about the effectiveness of remedies, without even asking you, maybe, without necessarily asking you to provide some examples, but from your, as a general statement, do you think it is realistic, it is possible, it is likely to for an antitrust agency to design an effective remedy which would ameliorate not only the situation with this specific case, but also for broader market, so to say, in the area of digital? Or it is, even with the toolbox like DMA, for example, it is next to impossible?
I'm very much waiting to see how the DMA turns out. I'm hopeful that it will provide the necessary teeth to actually achieve what you just tried to describe. I mean, broader, deeper, effective remedies, which very seldom have been achieved in the antitrust context. But I still have a healthy dose of skepticism. I mean, these cases are still going to take a long time. They're going to be appealed. We see what the gatekeepers are doing to try to delay things now. And the commission seems to be very determined to move as rapidly as they can, but inevitably there are going to be appeals, and inevitably they're going to take time. So we're still going to have the delay factor that has, to some extent, rendered remedies ineffective in the past. But very generally speaking, I do remain hopeful that it will work. Antitrust remedies, I've become very, very skeptical of over the years. It's probably best to use a couple of concrete examples, though. The Microsoft interoperability remedy did work. It made a difference in the relevant markets, but it only made a difference because the Commission was extremely diligent and expended huge resources to pursuing non-compliance proceedings, two non-compliance proceedings against Microsoft, and really got into the details. And this again was where the technological wherewithal was critical, and there were some very brilliant people in Cecilia Madero's team, in particular in DG Competition, who couldn't be hoodwinked. They weren't. Microsoft wasn't able to mislead them. I say this very bluntly, in the way I think they sought to do. With the relevant expertise, the relevant commitment, the relevant resources, I think remedies, even in antitrust cases, can be meaningful. Not that even that remedy was perfectly effective, but it was pretty effective. Since then, in my view, the Commission has not been as effective in ensuring compliance with the remedies that it's imposed. So, for example, in Google Shopping, the remedies have not been effective. In Google Android, they have not been effective, and that's both because of the formulation of the remedies and well, in my view, mainly the Commission has not pursued non-compliance proceedings when it should in at least both those cases. So bottom line is, with respect to Article 102, I'm quite skeptical about, in many cases at least, those cases ultimately yielding really concrete, effective remedies. I would be hesitant to advise a client that that's what they're going to get if they launch a case. And I think the dominant companies who've been playing this game, I think they realize that if they drag things out sufficiently, if they play hardball sufficiently, that they're not really going to have any serious changes to their business imposed upon them, because it's just not what's happened.
And speaking on the mechanism, you manage a large law firm, or you in the management board. How with the new commissioner, is it something which can be somehow quickly improved by changing the priorities, or it is within the institutional memory and it's like moving the tanker, requiring time? And
yeah, as you can see from this conversation, I've become a bit jaded over the years, and I've seen, my time goes back to Sir Leon Britton as commissioner, and even a little bit before that. So, been through the regimes of quite a large number of commissioners, and each commissioner has his or her own approach to things. And for example, the switch from Almunia to Vestea was a pretty substantial switch in terms of enforcement in digital markets. Almunia was in favor, and I'm not saying he's absolutely wrong and Vestea was absolutely right, but Almunia favored Article 9 commitments, resolutions of cases, and Vestea came in and said, no, that's not working, I'm going to enforce. So that was a pretty substantial shift. But the commissioners can only affect a certain amount. I mean, they definitely have a great deal of power, and the people in DG Comp have to abide by what the commissioner decides. But it is a bit of a tanker. I mean, really is a big oil tanker that you can shift only in certain directions. And of course, they're stuck with the law from the courts. So the commissioner can't just decide, I'm going to do this, I'm going to do that. I mean, the courts are always hovering above there, and the courts have become very serious. So to answer your question succinctly, I hope, I don't believe that any change in commissioner, either now or in the future, is likely to fundamentally alter the direction of this ship. I don't think that the law is going to be enforced any more particularly effectively than it has been, for example, under Vestea. She's been pretty hard-nosed about things, but she's up against huge power.
You mentioned very helpfully the role of courts and cases in 102, and we witness significant waves historically in different interpretation or different emphasis of the Court of Justice in reading the provisions of the treaty and secondary legislation, soft law, etc. So if I can ask you, how do you read? Obviously the courts are primarily focused on adjudicating on specific case. It's not their mission to build up a harmonious, holistic theory or vision or strategy, but we interpret it as it is. So where do we currently move with the latest cases? Is it possible to build a holistic vision about where the court is looking, or again each judgment or many judgments go in conflict with each other? It depends on two subjective matters, and it's maybe too early, premature to make such a categorical statement.
Yeah. Well, I think that's the challenge the Commission faces now with its guidelines, is to try to put together, as you put it, a holistic approach, in particular to Article 102. I think that's a difficult job. I mean, I guess it's not so surprising that the courts have not set out, as you aptly put it, a holistic approach to any of the areas of EU competition law, including Article 102, because they have to deal, as you say, with specific cases. But also, there are different chambers, there are translation issues. I think there are quite a number of things about the the European court system that make it more difficult to achieve a holistic, consistent approach than some other court systems. I think the UK, for example, or the United States. And I don't think that's going to change, particularly because I think it's pretty much inherent in the system. So the effects required in an Article 102 case. It's not quite clear exactly what the law is in that regard, because there are things in a number of different judgments from the European courts that are not entirely consistent. But I do sense the court headed. We'll see on September 11th what happens in Google Shopping. But I do think there are a number of key questions where the court seems to be headed in a direction of coming to what I regard as an appropriate balance with respect to how to approach effects analysis in Article 102. So I think they are likely to come down on with respect to what is required. What is it? Are effects required to be likely effects? Are they required? Is the capability of having the relevant effects sufficient? It seems to me they're likely to come down on something like potential effects or capability of having the relevant effects is the test, as opposed to a few cases having said likely. I'm getting into the weeds here, but likely seems quite different from capable of. And so we shall see where it turns out, but I think it's likely to end up there in that reasonable middle ground of that the conduct has the potential for causing the relevant effects. Then there's the big question of what are the relevant effects? Okay, maybe the conduct is capable of having relevant effects, but what are they? And there, I think the court is headed in the direction, but again, we have these cases coming down the line from the Court of Justice, which I think will be quite helpful, in particular both Google cases, the Android and the shopping case, in saying where the court is on this. But I think they're likely to come down with the position that is along the lines the European Commission is favoring and saying it's going to reflect, I think, in the guidelines that first of all, there doesn't need to be any absolute exclusion, any full exclusion from the market by competitors for conduct by a dominant company to infringe Article 102. That the conduct can be unlawful if it changes the dynamics of competition in the market. And in one way in particular, where you have smaller competitors who are not as efficient as the dominant company. And as I'm sure you're fully aware, there is this whole question of how the efficiency concept plays into Article 102. When is an as efficient competitor test required? What is the as efficient principle? It seems to me they're going to come down on as they have been in various cases coming down, that the smaller competitors, if I could just put it that way, need not be as efficient as the dominant competitor in order for Article 102 to be infringed. In Google Android, for example, that the smaller competitors arrived at a moment when the competition changed from the desktop to the mobile sphere. That provided great opportunities for a shift in the market. Google undertook conduct which the courts have found squelched competition from those guys, and the general court was quite clear, and I think that the Court of Justice is also likely, I'll be bold and predict that, to find that the fact that those smaller competitors were not as efficient as Google, and I would say inherently not as efficient as Google, that doesn't mean Google can engage in any conduct it wishes. It's not a get out of jail free card. You can do whatever the hell you want to do as long as the people you exclude are not as efficient as you are. I don't think the court's going to go down that blatant path. I'm not speaking very clearly now, but I hope you're getting where I'm headed. I think on these sorts of issues, the court is likely to come out after the existing cases pending before them are decided with not an entirely holistic, perfectly wrapped up with bows and ribbons, but a fairly clear approach to at least those issues on Article 102. I'm sorry, I'm rambling here now.
Not at all. I think you are crystal clear, and I wanted to follow to ask you a follow-up question, kind of sociological question: how judges think, so to say. Obviously, we understand that law is elastic and it is interpretable, and parties and judges interpret positive law, case law. But are they mindful of the huge implication about how they interpret adjectives, which are very synonymical in many respects, when how large the stakes are? Because if you put these words to a linguist, I imagine they will struggle to find the differences, or you can perplex them, so to say. Whereas in our context, these adjectives matter so much. Who decides based upon what? Upon the common sense, upon their understanding of what is the right answer, upon all things considered, upon something else? Is it a weight process between different judges, or it's something institutionally fed? How do you understand this mechanics of adjudication in this regard, at least?
Yeah, well, I'm not a judge. That's what my one professional regret. I would have liked to have been a judge, but now I'm never going to be a judge. So, but I'm not a judge. I've worked for judges. So I'm not sure I'm necessarily the right person to answer this question, but my perception is that in particular the European court system, where you have French, the working language, and you have quite a lot of judges who are not particularly adept in French. From talking to several former judges, I understand that leads to a fair bit of lack of precision, I might put it, in the use of language, in particular, which is what you're referring to, in the practice of the court, and that's reflected in the judgments of the courts. So I think the system itself, with French being the working language, lots of the judges not being very adept in French, and the considerable number of chambers. I mean, it's not like the U.S. Supreme Court. There's 9 justices, and they deal with each other over years and years and years. And there's then, I think, inherently more of a, as you put it, holistic body of law. You might not like the law, and there are going to be huge disagreements, especially today, amongst the judges in the U.S. Supreme Court. But the system itself is set up to achieve more holistic consistency. And also with respect to this language point, you have in the UK or in the United States or in most, in all the EU member states, Germany, France, they have their language, and the judges are very, very adept. They're brilliant lawyers, and language is their tool. And obviously, not everything is going to be crystal clear in that context either. But I think it's much easier to avoid these kinds of inconsistencies and unusual uses of terms, in my view, sometimes inconsistent approaches from one part of the judgment to another part of the judgment. Sometimes you'll see that. I think you see much less of that in national judgments because of this issue of it's a European institution. It has the greatnesses of a European institution, but it suffers from these difficulties that result from there being all sorts of different people and Yeah, the things I've already mentioned. So I don't believe that the judges are unattuned to the importance of language and how, to take the issue we were just talking about a moment ago, whether it's capability of causing relevant anti-competitive effects or the conduct is likely to cause. I think if you sat down in a room and you had a few of them and you said, well, isn't there a difference there? I think they'd admit, yeah, there's a difference there. But the system just yields these sorts of inconsistencies, which is unfortunate.
But on more substantive side, do you think that the evidentiary burden, the overall references to human rights vocabulary, and some other interpretation of existing law, is it, all things considered, does it make it excessively difficult for the Commission to succeed in one or two cases in the Court of Justice of the European Union?
Yes, I believe that the court has made it too difficult to succeed for the Commission in Article 102 cases. I think the term that Lindsay McCallum used in the webinar that we did fairly recently is, Article 102 has to be workable. Yes, we want an effects-based approach. We don't want a mechanistic, formalistic approach like existed in quite some measure 20 years ago. And effects-based requires effects analysis of economics and sophisticated approaches to the cases. But it has to be, the system has to be workable. And I do think that the court has in certain ways imposed burdens on the Commission that make it very difficult for it to succeed. Among other things, procedural things. Obviously, as a lawyer, I'm very big on due process. Due process is absolutely fundamental to our systems of law. But there have to be limits there as well. And I see the procedural requirements that have been imposed on the Commission quite often in 102 cases, leading to situations where dominant companies can exploit those procedural requirements in ways that don't really matter to them, but they find ways to use those requirements to delay, and impose greater and greater substantive requirements, in a sense, on the Commission by virtue of the substantive law as well. So the procedure and the substance interacts to make these cases very, very difficult to pursue.
Without moving to technicalities on the draft guidelines, because we'll soon have a separate panel on this topic specifically, I wanted to ask your feeling, your vision about the possibility, the potential of the introduced of the launched reform by the Commission in interpreting the guidance paper and in discussing the draft guidelines. How far it could go, even if successful? What are the limitations, and what is the potential?
Well, of course, the bottom line is it's the courts that are going to decide the law in the end. So that's really an important bottom line. But we saw the 2008 enforcement guidance had a very significant effect upon the courts. I mean, the Commission did what it said it was going to do with respect to enforcing cases. It adopted a more economics-based approach, and the court went along with it. And so we have that example in this particular context, at least, as when showing that when the court makes reasoned, sophisticated arguments or presents its analysis in a reasoned and sophisticated way, that it can have a very significant effect in documents like, we have only one example. We have the guidance, the 2008 guidance, but still, it had a big effect. It is to drop a footnote here. One thing that's interesting, as Richard Wish said in that webinar that he and Lindsay and I did, the Commission couldn't in 2008 adopt guidelines because the court's case law was extremely formalistic, so they would have enshrined in guidelines exactly what they didn't want to see, a very formalistic, mechanistic approach. Just as a historical footnote, that's interesting. Now we have the court has been unleashed on a very effects-based approach. One question I have at least is, maybe now the court thinks, okay, we understand this stuff. We've now got a substantial body of case law. We've been dealing with these Article 102 cases in effects land for quite some time. We don't really need the Commission telling us anything about this. I don't think that's likely to happen. I think that there will be a useful interaction. But is the court just going to accept necessarily what the Commission says? No, I think they're going to look very critically and carefully at it. But I think it could be very useful, frankly, for all of us, including the court, to have the Commission put it all together. To say, there's all this stuff out there in terms of case law, and to try to make sense of it. And so I hope the Commission, and I think the Commission it'll be cautious. I don't think the Commission's going to go off on any wild limbs and make arguments that just don't make any sense. I think they're going to be fairly cautious about it. They obviously have their perspective, and I think they'll try to embody their perspective in the guidelines. But I really think they're going to be careful. And if they are, and they're sophisticated, and they are very sophisticated people, to answer your question finally, I think it'll have a significant influence on the court and on the evolution of the case law going forward.
The DMA. You mentioned that the cases, however, even if you succeed, it seldom delivers some systemic implications or remedy some systemic market failure, or goes even further, trying to tailor, to shape proactively some market in specific trajectory for whatever policy-driven purpose. The DMA does provide such toolbox. It does provide the necessary teeth, as you mentioned, to be more aggressive. But also, I imagine it's not an encouragement to do enforcement on steroids, so only because you can. So it envisages some priority setting or some selectivity, some strategic foresight, or whatever it could be. So the all-inclusive objectives of fairness and contestability they have variety of different ways. So my first question about the DMA: how do you see this fairness and contestability? Is it the sum of obligations? Would we achieve fairness and contestability, or sufficient level of fairness and satisfactory level of fairness and contestability, if we assure that all designated gatekeepers in all core platform services comply with all catalog of obligations? Or it would be too mechanistic to consider it like this?
I fear it would be too mechanistic, but at the same time, in theory, if the Commission were to do what you suggested and to enforce every obligation fully and effectively against all of the relevant gatekeepers, I think it would make a big difference in achieving fairness and contestability in digital markets. So I doubt anything, I'm sure you don't think either, anything's going to be perfect and we're going to end up in an absolutely perfectly fair or contestable world. But I do think it has the potential, at least, for being much more likely to achieve that result than enforcement of the treaty is. But I do have great concerns. Maybe I could say just a few words on that. I mean, your ideal world, I think, at least ideal world for me, is they enforce everything effectively. But they have very, very few people to do it. So if you think of that group of, 80 people across DG Comp and DG Connect, enforcing all those obligations against the most powerful companies on earth, no matter how brilliant they are, no matter how committed they are, no matter how hard they work, and I know people in DG competition very well for many years. They're some of the hardest working people I know, so I don't doubt they'll work hard at it. But it's just not enough. The resources are just simply not adequate, and that's not the Commission's fault. I mean, the member states need to give them the money. I mean, they don't. It's fine for the Parliament and the member states to adopt legislation, but like the DMA, but it has to come from the EU budget, the resources to enforce it. So, so if your theoretical ideal world doesn't arise, I think it will be largely because of lack of resources, and that will be because, despite all of the nice words from the Parliament and the member states, they don't put the money into it. Other than that, even if there were a much bigger team, this is enforcement against the most powerful companies on earth. They can have the fanciest lawyers and innumerable quantities of them, brilliant people, and they'll have some good arguments. So I'm worried about how the DMA will turn out. I'm involved in the enforcement against Apple, and I see, to be very blunt, Apple running rings around the Commission, just absolutely failing to comply with the DMA. But they seem to be completely intent on pursuing that policy. Now, the Commission might impose gigantic fines upon them, which the DMA enables, but even if it's tens of millions of euros, will it actually achieve compliance? So I am skeptical that this ideal world will arise.
And isn't it the case, or how do you read this message about regulatory dialogue, participative approach, that it's less about enforcing or trying to problematize any potential instance of non-compliance, but rather to nudge the gatekeepers to a more amicable, less formal, quasi-commitment style settlement, in return to promise to turn a blind eye to other potentially problematic issues, particularly because we have shortage of resources? Is this more kind of collaborative modality? Does it have a potential, or it's something just more illusionary and idealistic?
As many of your questions, that's all of them. That's a very good one, and I think that depends on the circumstances and on the company. Having been involved in lots of these kinds of cases and having resolved some of them, been on the defendant side and resolved some of them, I've had some clients who are much more flexible than others, just put it that way. So I think there's, among the gatekeepers, there is a bit of a spectrum of different cultures. Some of them much more willing to be flexible to accommodate demands of the Commission, sometimes to be able to see that there is some wisdom in the DMA, although the gatekeepers generally tend to reject all of it. And with those kinds of companies, at least with respect to the issues there's flexibility on with respect to those kind of companies, I think the sort of approach you outlined is absolutely the right way to go, because why expend resources in a much more demanding enforcement proceeding when you can reach a reasonable result? It might not get the Commission everything it wants. It might not embody the absolute enforcement of everything the Commission thinks the DMA means. It might be some sort of compromise. That's life. But I think so that can be more effective. And as you indicate, then sometimes the Commission lays off on certain things that aren't as critical. I mean, an idealist would say the law is there, they have to enforce all of it, it all has to be fully enforced, but that's not the world we're going to live in, especially given the resource point. There are other companies at the other end of the spectrum who are never going to comply, and it's a waste of time to seek to undertake that sort of collaborative, as you might call it, approach. It's not going to work. By their nature, they are arrogant, They don't believe the DMA should exist. They deeply believe the DMA shouldn't exist. They think it's bad in virtually every way, and they're going to fight it with every dollar and every ounce of power that they have. So trying to agree things with them, I think, only after they've been really forced to confront the fact that if they don't comply, then it's going to hurt a lot. And whether the DMA actually enables things to hurt a lot, though, is the big question. So some companies might just get away because they're willing to plow whatever money and power into it they can, suffer any consequences in terms of fines or the like, and just power forward. And that could very well be the way it ends up with some of them.
But zooming in and looking at those who would be interested, in some cases at least, to be more cooperative and more amicable and more seeking a resolution. This would require probably from the Commission rather different, or from members of staff or case handlers, a different vision, because unlike the ex post cases, you have the beginning and you have the end, and you live in this microcosm, as you explained at the very beginning, Fujitsu, IBM. You delve deeply and you look at the technicalities. You don't look at the broader context. Whereas here, when you engage in this dialogical relationship, it probably may imply that you somehow, it's a bargaining game with many many factors. So
yeah.
Does this directorate consisting of DG Comp and DG Connect, do they have the sufficient, or is it possible to create such a mechanism, or it is already inherently within the Commission and it's just a matter of refining and fine-tuning some elements, or it's something, it's institutional building completely from scratch and we are witnessing this experiment?
I think the Commission is quite capable of doing what you suggest they need to do. I mean, there are, of course, a junior case handler in DG Competition, which of course I know best. They're starting out. They're going to be focused on the technicalities, as they should be. But you can't expect somebody who's been a lawyer for 3 or 4 or 5 years to be able to have that broader vision and to put things into context and decide, do we go after this? Do we lay off? What is the big picture? But DG Comp has people, Lindsay McCallum, Olivier Garçon, people I've dealt with for many years. And, they are very, very sophisticated. They're really among the more capable people in any context like this to be able to make those sorts of assessments and to give some when they need to give some, and to have, the word you used, holistic perspective on these things. So I think that the Commission can achieve. You also have, the commissioners are pretty damn good, and you have people in their cabinets. Vestager's cabinet I know best. They're brilliant people. I know the ones who deal with competition law and the DMA best. They're really, really good and very, very able to see this broader picture that you need to see to be able to achieve what you suggested. So I think there's the capability. Whether everything else comes into place to enable it is a big question.
Let us have a look at some digital markets themselves, and we have entrenchment, which is omnipresent pretty much in all corporate form services. But the easiest intuitive example is search engine. So we see some newcomers trying to trigger our European feelings of privacy, our concerns, and for some it's obsession even. And they promise to be more privacy mindful, etc. Others will try to exploit our feeling of environmentalism, and they promise to plant trees in some remote places. Whatever your experimental or your creative mind allows you to put forward in order to try to launch competition. Is it a sign that there is no other way to compete on traditional key performance indicators, so to say? And is there any solution to it? Or are digital markets systemically entrenched, and we are talking about utilities, that the purpose of regulator is primarily to bring some transparency, some accountability downstream or vertically, rather than looking at horizontal solutions.
Yeah. Well, I think that brings us to the DMA, but let me start at an earlier step in my thinking there. I mean, I've been dealing with search engine issues since almost the time they were invented. I represented Yahoo for many years, beginning within a couple of years after they were founded, and went through the whole process of evolution of Yahoo. They made some mistakes, clearly, and then when Google became the dominant force it did, I had a lot of dealings with issues for Yahoo and others in that context. And from focusing a great deal on those issues with technologists, experts in search technology, economists, and the like, it's clear to me, and I think that the Commission's decisions reflect this, and the Court's decisions to some extent as well. It really comes down to data. I mean, Google's power, its market power, derives from its huge advantage in data, and especially search query data in the long tail, which nobody else can even come close to matching. And so that gives Google just an inherent advantage, and it makes their search engine a better search engine. I'll readily admit that. They are able to provide more appropriate search results, relevant search results, by virtue of having that great scale advantage in data. So that leads to the question whether anything can be done about that, or whether the only way you can play in that market is by focusing particularly on privacy, like DuckDuckGo or Ecosia planting trees and stuff. The DMA seeks to address this data point, as I'm sure you're aware. Will that work? That's the big question. We don't have an answer to. I'm not so sure it's going to actually work in a way that would enable those who wish to compete on the same sorts of terms, in the same sort of way that Google competes, to actually match their to eliminate Google's data advantage. If that can be achieved via the DMA, we could have a new ballgame. That remains very much to be seen.
And obviously, the same question can be channeled to all other, or most other core platform, designated at least, core platform services within the DMA. Do you know, maybe by any chance, maybe we can see search for some examples in other jurisdictions which in one way or another prevented Google from becoming the incumbent, so to say? Do we have such examples? Are they representative? Are they replicatable, so to say?
I'm not aware of any antitrust or any sort of government interventions that have yielded that. I mean, we don't have time for a long discussion of it, but the Czech situation is quite interesting insofar as Seznam no longer is the power in search in the Czech Republic that it was, but Seznam for quite some time outcompeted Google in search in the Czech Republic, and it did so because it had a greater position in data than Google. That's now different because Google basically has such power, and it's overcome that. But I'm not aware of any sort of legal enforcement that has been at all effective in changing that balance.
Mm-hmm. Yeah, because obviously the question is, can you succeed commercially while remaining a good guy, so to say? Do you have to be in order to get these strong muscles, do you need to use steroids, doping, and all this kind of infringing cutting all possible corners? That's the question. people ask.
I don't know that. I definitely, absolutely do not think, and I think the world is filled with examples of innovators who come up with great technology and succeed in markets by virtue of that innovation, and don't and sometimes gain market power and don't succumb to the incentives to leverage that market power into adjacent markets, or when threatened in their core markets to engage, to throw around their existing power in ways that excludes those competitors, or by buying them up, or by engaging in conduct that forecloses them. That is a huge incentive, and I'll readily admit, and it's human nature. I mean, if you're Microsoft and you establish what you established with respect to Windows, and along comes the internet and Netscape browser, and they threaten your fundamental position in the market because you're going to move computing up a level, you're going to commoditize the operating system. And that's what Bill Gates talked about in his he called it his internet tidal wave memo, which he sent around Microsoft. He saw, he's pretty damn brilliant. He saw what was coming. Although it wasn't maybe that hard to see, he just saw it earlier than others. And so the incentive is, let's just throw around our market power and kill off that threat to our wonderful, very, very profitable position. It's a natural human impulse. It's illegal, and it was found to be illegal by the U.S. courts, but it is natural. But some people, I'm not saying everybody succumbs to it. I don't believe that.
Great. Let us move now to the last part of conversation, where I wanted to ask you a couple of questions about maybe to provide recommendations to students, those who just at the beginning of their career. But before this, I also wanted to ask you about your how you observe and maybe what you could recommend to people who already in their mid-career stage, who confront with new challenges, because so much is going on in our field. You have to keep reading, you have to keep thinking, you have to keep discussing the issues, you have to engage in so many different games simultaneously. You probably started witnessing this challenge of information flood some time ago. Maybe you have developed some successful, again, replicable solutions, or is it too individual to share? Or maybe we can learn from you a little bit as well.
Really, I have to say that I feel like I fail at dealing with the information overload, and it gets worse year by year. I'm very, very lucky, unbelievably lucky, to come back to the point about the team, that I've had a team around me of brilliant young lawyers, and they read a lot, they learn a lot, and I leverage that broader resource and take things from them, because I simply don't have time. Given other management things I've had to do and stuff like that, I feel very guilty, but I can't keep up. So I can't really give any good advice on that regard. You should speak to the younger people who I rely upon. They're better at it than I am.
I certainly will, but I'm sure if you try to visualize or try to do to look backward and imagine if you are a young student just about to graduate from a law school, what are the things which you would try to focus and things which you would recommend to avoid?
Yeah, well, one thing I would say that I've always said to younger lawyers is in my field has been technology, so I've always tried to hire younger lawyers who have a passion for technology, and I tell them one thing you really need to do is not only to learn about the key legal topics that are relevant to your practice in that digital area or technology area, whatever it is, but you need to read magazines, various sources of information mainly going to come from the internet these days, about those technologies, about those businesses, and learn how the businesses work. What are their concerns? What drives the businesses? And if you don't have a genuine curiosity for learning about, just take search engines, how they work, what are the factors that make one successful and another not successful, and just basically what are the guts of them, what's the technological guts of them, what are the economic drivers, all that sort of stuff. If you don't have a curiosity about those things, then you're in the wrong field. You should, maybe you're more interested in wine production. I have a friend who was the European Commission's expert on the law of wine, and I thought that was a pretty great job, and she did too. So I would, find something that you feel passionate about, that really, because of your background or whatever, whoever you are, means something to you. Don't try to stuff yourself into a bottle you don't fit into, because that's likely to fail.
Thomas Vinje, thank you very much indeed for sharing your excellent ideas with us.
Oh, thank you, Oles. Thank you. Always very nice to see you.